Okay. I think we're going to get started again, if that works for everybody. So I think they're done clearing this. So one thing before we move on to talking about best practices and sharing the children's views is with your meeting with children at the very back of that PowerPoint presentation are all kinds of sample questions that might be helpful for interviewing kids. I didn't go through them all, but there's kind of there that you're welcome to use, modify, do whatever you want with them, but they're just samples. Never hurt to have that for people. So we spent the morning learning about child representation, how you get appointed, what things you might want to have in your order. We also talked about meeting with kids and how to build rapport and get things out of them. Now we're going to talk about what might be some of your best practices and how are you going to get that information before the court. Now you've got all this, you've done this work, how am I going to get it there? And again, just to remind, what I share is just sort of my experience. I'm not saying this is the way it has to be. I've practiced in Ontario. I know how they do things there a bit. I practiced in Alberta. That's not to say that's how it has to be done in the Yukon. So I just want to make that caveat that this is just helpful information. Do with it as your heart's desire. So I think I had said to you earlier that representation of children is incredibly rewarding work. Kids are by far my favorite clients. You can have such a huge impact on children's lives, but having training, having experience, doing it well, because kids, if they have a bad experience, they'll remember that for a long, long time. But it's also an area of practice where, particularly in the high conflict world, it's an area where people get complaints as counsel. You get complaints as children's counsel, get complaints to the Law Society. So developing best practices that you use throughout and do the same thing on same files does help when it comes to times that you ever have to defend that sort of thing. And it's also good just to train yourself so you're doing the right thing. So at Legal Aid Alberta, we have prepared a best practices document that we can use. So there's copies over there for people. Not saying you have to use it, but so one of the first things we do is, as I indicated before, we used to get court orders that said, this is the role that you're going to take. You're going to be an advocate, you're going to be a direct advocate, you're going to be a best interest role. So we always say, look at your order first. Has the court already made a determination what they want? And do you think that's the right one or not? Meet with your child. I indicated earlier this morning is we send out a very standardized letter every time we make an appointment. So every time there's an appointment for children's counsel that says, hi, I'm so-and-so, I've been appointed pursuant to the order of blah, blah, blah. And this is my role. I want this information. These are the type of collaterals I may talk to. These are these are the roles I may take in this particular matter. And please include me in all correspondence. Please include me in scheduling meetings and court dates and that sort of thing. And we also ask, can you please, from the parents, can you please provide me a list of the collaterals, the professional individuals that may be involved with your particular child client, be it a counselor, be it the school, be it the doctor if the child has health-related issues, be it a psychologist if they're seeing a counselor, if there's an assessment being done. So you get that information up front. Really try to be neutral and transparent with what you do. If you're neutral and you're transparent and you're not biased and you maintain your independence, you're less likely to have problems and concerns. Do you get swayed by one or the other side? Yeah, for sure. Your child may be swayed. But it's really important, even as I said, where you sit in the courtroom, that your appearances and how you behave, where you sit, the position you take, all reflect. So as I said, I always try to sit in the middle or kind of lower on the side. So it's not looking like I'm taking mom's side or dad's side. Set up your file, review your pleadings. Some counsel I know who did the children's counsel work don't want to read anything before they meet with the child. They think that's best. Not my practice. I like to know what the issues are. I like to know if there's information in those pleadings about or in the affidavits about my child client, if they have special needs, if they have particular interests. I like to know that. If there's allegations of sexual abuse in particular, I want to know that because I want to be really careful because I'm not a forensic interviewer in any way, shape, or form. I want to be careful that I'm not doing any damage and I'm not tampering in any way, shape, or form with evidence or anything along that line. I generally, and I said, my practice is not everybody's practice. I generally don't have a lot of communication with the parents. I don't meet with the parents. I even have my assistant schedule the appointments with parents. Some counsel will meet with each of the parents and get their perspective on things before they meet with the child. Again, had few bad experiences that I'm really careful about what I do with that, but not saying you can't. Just be really careful about what you do and make sure that they know your children's counsel, because so many people think you're everybody's lawyer. You're going to explain their rights, their responsibilities, and often you are the only lawyer on the file. I'm not sure if that's the situation in Yukon, but often we find, particularly in the lower court on the parenting matters, that we're the only lawyer on the file. Again, I try to rotate who brings the kids, depending upon the situation. Kids are influenced by who they may have had the car ride with, who's got the plans afterwards to go for ice cream. Prepare for your meeting. Have your tools ready. What are you going to use? How are you going to build rapport? How are you going to interview? And I like, and again, not always possible, because often we'll get appointments like the day before court. You're lucky if you can see the child. I like, before I'm giving an ultimate position to the court, to have a minimum of 3 meetings with a client. One with mom bringing, one with dad bringing, one I with, just so I can ensure that there's consistency in their views and preferences. Does it change every time a different person? Has something happened that may have caused them to want to change their views and preferences? But no overkill. You don't need a million things. I think one of the most important roles that Children's Counsel has, regardless of what role you're taking, is that helping the court get information from professional collaterals. Speaking to, like, who are those people who are involved? I don't necessarily want to talk to grandma. I don't necessarily want to talk to the neighbor. I don't want to talk to a character witness here, somebody's letter from their friend. I want to talk to professional collaterals who are involved with the child. Again, depending upon what the issues are. If there's no medical issues, I'm not going to bug the doctor. If there's educational issues, there's absenteeism, a child has an IPP, an education plan, then yeah, I'm probably going to want to talk to the school. I'm going to want to talk to the teachers. If they're meeting with a counselor, probably going to want to talk to a counselor. We had some discussions earlier about that's one of the really good things of having a really solid court order appointing you. You get that provision in there, which will pave the way for your ability to be able to access that type of information. If there are medical issues, you get a special needs child, a neurodiverse child, you're going to want to get yourself a bit educated on working with neurodiverse children, or if a child has cognitive issues. Again, you may, if you're doing the work from the child welfare side of things, you're going to have lots of kids with cognitive issues. And again, when you're in children's services, it's a bit different, because you have the director, or whatever they call children's services. What's the person who is it called? The director? You have the director or the director's counsel that's collecting a lot of the information, putting that evidence before court. If you're in family law proceedings with just moms and dads and there's no counsel, you're doing a lot of that work. For academic issues, meet with the school. Read those psychoeducational assessments, get copies of them, read the report cards. Schools see kids often more than their parents do. If they're not in school, that's a reason to be really concerned about what's happening. I've even gone to, in Alberta, they have, what do they call them? They're not detention review. They're kind of like a detention review to a kid. But when kids are absenteeism, they'll have absenteeism hearings where parents have to come. And I've gone to some of those to kind of explain why. If there's a counselor, make contact. Does the child need counseling? You heard me kind of talk in role play. Would you like to have somebody to talk? I'm not saying you're going to make the decision, but it's maybe something that you raise with a parent. Maybe given the level of conflict here and all the toxic stress these kids are going through, maybe it does make sense that they have a counselor to talk to. Again, when I said earlier, and I'm repeating a few things, but the justice wasn't here for some of that. Most of the work I do now is in the high conflict world versus the child protection world. So often when you have the high conflict stuff, you're going to have overlay with child welfare matters. So you as Children's Counsel have to decide, do I need child welfare disclosure? Are there things in there? You're going to know from reading the materials. If there's allegations of abuse, has Children's Services been involved? Do you need to get that disclosure? Do you have it need it in every file? No. But if there's been serious involvement, you definitely want. There's different ways of doing it. Sometimes you get a court order that says you're going to do it. Other ways, if you have good relationships with the Director's Counsel, you may be able to send a letter and they may send over the information to you. But in Alberta, the process of getting, if you have to go through a formal application, you make your application and the justice has to screen through everything to decide what to give you and what not to give you. They don't like doing that. takes a lot of time. So be really specific as to what it is you're wanting. You may not need every contact note. You may be wanting the police reports. You may be wanting the assessments that are done. So be specific because you don't want them reading thousands and thousands of pages. How are you going to use the information? Depends on what your legislation has to say. And in this day of the internet and people posting things all the time, you have to be so very careful what you get. Often we'll get it in Alberta when child welfare disclosure is given to council, be it on a child welfare file or on a family law act or divorce act file. It's often with an undertaking. A council's undertaking that you not release the information. So if you're sharing things, you have to be really careful. Sometimes if parents are self-represented, they'll give it to them, but you have to worry about terms and conditions about, you don't want this to appear on the internet. You don't want things out there that kids are going to have to live with for the rest of your life. So be really careful and be careful how you use the information. Again, you're really going to want to know if there's some previous orders. Have there been applications for what we call a supervision order, a temporary guardianship over, or a permanent guardianship over? If there has been previous involvement, you're not sure, ask Child Services. They can run the names and tell you whether or not there's been involvement. When you're in Alberta, as I indicated, LRCY, the Legal Representation of Children and Youth, is done through the Office of the Child and Youth Advocate there. Council automatically get copies of all of the disclosure. If you're on the family law stuff, you have to take a process. So I won't go through all that, but really know what it is you may or may not want and know if you need it. If you're in child welfare matters, I assume council automatically get disclosure. If you're acting for a parent on a child welfare matter, do you have to make a request for disclosure? No, they just send it over.
Just if it's a family law matter, then we have to get an order.
Okay.
But yeah, they automatically send it once
And
they know that we're on file.
Are there terms and conditions regarding getting it? Like, do you have to sign an undertaking? Do you have to say you'll destroy the evidence afterwards?
Not on the child welfare ones, but on when it's a consent order, yes, that includes that language, right?
Yes, right. So for child welfare, I mean, any party gets all things automatically. If you want full disclosure, our strong preference is to use a consent order, just so it's clear that all parties get it and have some terms around what we're redacting and sharing, things like that. So our legislation is fairly strict about, especially in family law.
About reproducing it?
About just the ability to attach terms and conditions to the disclosure. And then even in child welfare, if you want all the contact notes, everything, your parties are entitled to it, but we do like the consent order to be able to put those terms on it.
Okay, so be specific though. Are you with Legal Aid or are you with the directors?
We're all three of us are on Directors Council.
Okay, very good. Good to know. Thank you for sharing that information. So in Alberta, it's section 126. There's probably a similar provision here, so I won't go through, but just really think about what it is you're doing, what to request, what are the things from Children's Council if you're doing the high conflict work? What is it you're going to want from that file? And those are like things, assessments, mental health evaluations of the parents and the child. And you'll notice that order says it's not just information regarding the children, it's parents and children. Medical reports, police reports. Again, as I mentioned earlier, police, some of them are great. They'll share anything under the sun. They're just so happy to see that there's counsel for a child on there. Others, like RCMP, you need to have very specific orders. If you're wanting things like, I don't know what the equivalent would be here, but if you want reports regarding threat assessments on children and on families, things like that, they want very specific orders to release that sort of information. Best practices, how do you share the information you've collected? How I like to do it when I share information on it, particularly on a parenting file, I like to get everybody in the same room. You heard me talk about that. Everybody in the same room. So they're hearing the parents, their lawyers, Children's Council. You're all hearing the message at the same time. So you're not having side conversations with this parent. Oh, they told me this, they told me that. No, everybody's hearing the same thing at the same time. I usually share who I've talked to by way of who the collaterals I've talked to generally, unless they've asked me not to share things. And then we talk about how do we resolve this matter. Now that we've heard from the kids and we've heard what's working, what's not working, what can we do? What things can we do to make this matter better? and how can we get these kids out of the toxic stress that they're living with. In our order, as I highlighted earlier, there's a very specific provision that allows Children's Counsel to do an oral or a written report to the court. Again, non-evaluative. You're not evaluating the situation. You're providing information to the court, but you're not deemed to be a witness. When you go to a trial, though, it's up to the justice as to whether or not they consider that to be evidence. I've had cases where they enter it as an exhibit, but they don't necessarily, it's not evidence. I'm not taking a stand. Children's Counsel should never be taking the stand to give information. We also talked about in Alberta, we have the ability under our practice note 7 to get a voice of the child report. That's where you're hiring a parenting expert, a psychologist, or a very experienced social worker to do an evaluative voice of the child report where they meet with the child a number of times. They generally will meet with the parents as well, hear their positions, talk to the child, and then do an evaluative report. Those are often used if the court is concerned or counsel is concerned about those situations of alienation or undue influence, or just to make sure if matters going to a trial, to ensure you've got somebody to give the evidence. We heard about in Ontario, where the Office of the Children's Lawyer will have a social work assist. So you've got a person to give that evidence and you're not as counsel. Strobridge says we cannot give evidence from counsel's table unless there's consent of everybody. So we have to be careful with that.
The issue of providing a report is also a bit of a touchy one because we have opinions on that. Many years ago, there was a case, Jane, I think you recall that one better, where the child lawyer was crossed on the report.
Yeah.
So the practice that I've always followed was to write a letter to counsel or for the parties or counsel, self-report, whatever, and then ask them to attach my letter as an exhibit to an affidavit, so that I could not be cross-examined on a so-called report, given that case. Now,
Well, it was an exceptional case in the sense that the child lawyer filed about a 40-page report with the court, which included lots of conclusions. And when I objected to it being filed, I said the only way this should be filed would be if you're willing to subject yourself to cross-examination on the report. And she agreed. So Justice Madison was presiding, so it tells you how far long ago.
Yeah, there are nobody in the room.
92. So the only reason that she ended up on the stand was that she had consented to being cross-examined, and Justice Madison at the time went, okay, let's do it that way then. So that's been the only time.
And that's kind of part of the reason why sometimes having a settlement meeting outside of court, you don't have the judge there, gives you that opportunity to share with the parents what the child's position and gives them a little bit of an opportunity to ask a question, not cross-examine, but ask those questions so you know that information going in. I know I sometimes will get orders from the court saying I want a written report. I'm hesitant with that. I'm really careful about what I put in writing because particularly once it's out there, how often you have kids like, Mom, show me the letter. I didn't say that. I didn't do that. So when I do concise letters for the court, so we have special chambers in Alberta and counsel have to do materials and a concise letter, which is kind of their position in the case law they're relying upon. Children's Counsel will file a concise letter, but I do it sort of under the same sort of conditions that we do with a practice note 7. Parents are not entitled to a copy of the report. They can review it. They can review it in their counsel's office, but they don't get access to a copy to have to put on the internet or whatever, or to cross-examine the child about it. Or we put a trust condition on it. We send this out to counsel on the trust condition. You can allow your clients to see it, but not to have a copy of it. And for self-represented individuals, what we will either do is sometimes have them come to the office and give them a room to sit and read the report, because obviously they're entitled to see what it has to say, sort of thing, and take notes, but not take a copy of it. And we often tell them they can't have their phone in there as well. Or the court will sometimes allow an opportunity, just like they do with the PN7, will allow them to come to the court to sit in the boardroom and review it, but not take copies of it. So you always have to think what you're putting in writing, think where will this go? Is it evidence? It shouldn't be evidence, but the court will sometimes rely upon it. And again, you're always kind of thinking about if this goes to trial, but vast majority of the files we have children's counsel on, you're not going to trial. I think you had indicated you've hardly done many trials with children's counsel in the many years you've been with. So again, the whole message of children's counsel be part of the solution, not part of the problem. So you're always trying to help people resolve things. So query whether or not you need a parenting expert. And it sounds like even if there is a need for an assessment, there's some mechanisms within your legislation to be able to do that. Do you need an expert to testify at a trial? Report back to the child client. Some people do files and they never report back to the kid as to what happened, how their information was used, how the judge may have taken it into consideration. Always really important to indicate to kids that, you know, your views and preferences are really important, but it's ultimately, you're not the decision maker. It's going to be a judge. It's mom and dad hopefully will come to a decision. They're not able to, a judge is going to do that. And you're one of the many factors they're going to look at, and they're going to decide how much weight, how much importance is going to be on your views and preference. So always send a message to kids that they don't have to choose. They're not the decision maker. We care about what they have to say, but it's only one of the many factors. Be conscious of your interactions with counsel, parents, where you position yourself in the courtroom and meetings, all this. If you come in as children's counsel, you should be independent. You shouldn't be sitting with the director's counsel over there the whole time and laughing and giggling with them and not speaking to the other people. Parents, that stuff matters. It matters to people who you're helping and who you are serving. It matters to parents. So be transparent. Children's counsel shouldn't be choosing. You may be putting a position before the court, but that doesn't mean you don't speak and don't alienate the other parties. Be as professional as you would be otherwise, if anything, more professional than you would be otherwise. Practice defensively, have best practices so you're doing the same steps in all of your files. As I said, it's a high-risk area. Be part of the solution, not part of the problem. Okay, how are you going to get that voice before the court? Are you going to stand up in court and say it? Are there other ways? And again, this is a bit geared to trials as well. So sometimes you get evidence before the court to the parents. Parents will say, Johnny told me this, or Sally told me this, and you will have, parents will put in affidavits. You as children's counsel will have an opportunity to cross-examine the parents, and that's where often you can get the information in. You know what the child has told you, you can put questions to them, and sometimes the evidence will come out that way. So as child's counsel, you have to have really effective skills to be able to cross-examine people. Sometimes you can have direct evidence from the child, an affidavit to testify. I can honestly say I have never done an affidavit for a child in all my days. I would be very hesitant to do so. The only time I might assist is maybe with a letter from a child, if it's in the circumstances where you're preparing it with the child and you're kind of know what the environment is. The last thing you want to see is parents do it all the time. They put a letter, get Johnny to write a letter in their handwriting and attach it to their affidavit. I have yet to see that ever help a party. I think if anything, that goes the opposite direction. It looks, what was the environment? What were the questions? What were the circumstances surrounding? Those are the sort of things that you have to think about and question about. So sometimes I've seen videos from kids. I don't like that either. I think parents who put videos of what their kids, again, that speaks volumes to me. I'm not sure about everybody else, but putting your child in that situation to go through that speaks volumes of how you're protecting their best interests as far as I'm concerned. I will often have other adults testify, be it a parenting expert or be it a principal or a teacher. I'll sometimes get their views and preferences in. Have they shared? The counselor will do that as well. Voice of the child reports. Judicial interviews. Again, that's been around for many, many years. Some people are really in favor of it. Other people are not. I think I've been going to the National Family Law Conferences, I think, since 92. I don't think I've gone every 2 years, but I've been to the vast majority. It's been a discussion point for many, many years. One of the decisions, Madam Justice Laparco in Edmonton has done a recent decision a couple of years ago now, SK, which is referenced in one of the presentations, and she did a whole section. She decided to judicially interview a child and talked about the rules. It's only one tool in the toolbox for justice, but she talks about the circumstances surrounding and some of the guidelines. I can tell you she authored a paper for the She did a presentation for the National Judicial Council on judicial interviews, and I actually co-authored part of it along with another colleague, Jeff Keller, and just talking about how can Children's Council, if there is going to be a judicial interview, what role could Children's Council play? How could they assist? I know I've only done maybe a couple of judicial interviews in all my years of practice, but when I ask for one, there's usually because we've tried every other option and a child really wants to speak to a justice. I've had that a few times. They didn't necessarily always accede to my request for it, but Children's Council is asking for it. It's probably something that they really think is important, particularly if they've worked with the child for a long time. I've had it more with older kids. I had one kid, I took over the file. Again, I'm calling them kids versus young adults sort of thing. But I took over a file, one of my colleagues had it. She had seen 20 different professionals over the years. And this was this was not a child welfare matter. This was a high conflict parent. They had spent 10 years litigating. She had seen parents each went through 2 to 3 counsel. She had 2 children's counsel, and she had seen a combination of 5 different psychologists. And she had been consistent throughout her position for the entire period of time. And the other side wanted to do work with yet another psychologist to try to get this child to change her views and stuff. And she said, I'm done. I'm done. I'm not talking to you. The only other person I want to talk to is the justice. So when I raised it, he didn't do it. The matter didn't go any further, so it worked out perfectly, sort of thing. But there is a paper that I'm happy to share with people on judicial interviews. And I know in Edmonton, there was just a judicial conference in January that I spoke on at a panel. And one of the justices there out of Calgary, and I forget her last name, was working on guidelines for justices if they want to do it. It's not a mandatory. There are some places where they do judicial interviews on a very regular basis. Quebec is one of those jurisdictions where often they will speak to children. It's just one of the tools in the toolbox. And the last one is parenting assessment. I'm not sure how often they happen here. We call them parenting assessments, bilateral assessments, forensic evaluations. They fall under PN8 in Alberta. The cost of those is anywhere from $20,000 to $40,000. So Legal Aid Alberta, we're not funding any of those. And often they take years to be done. By the time it gets to a trial, they're usually outdated. So very few people are doing those.
So the judicial interview, how do they do it in Alberta? Is it done on the record? With parties, with counsel present, or what's the situation?
Well, in that particular file, so there's no set guidelines at this point in time. They're working on them. But in that particular file, Justice Leparco had who was present in the room was the child, the court clerk, the justice, her counsel, the child's counsel. Parents' counsel weren't. She took a recording of the interview. So it wasn't evidence. It wasn't evidence for purpose. She just wanted to meet with the child and hear from the child directly. And she took a recording of it. It was sealed on the record and was only to be released if there was an appeal of the matter. So other counsel are not present. So she may give an overview of what the child had to say in that, but they're not going to be there. They're not going to be questioning. They're not going to be listening to it. Sort of thing. That's generally how it's been happening. It's usually children's counsel, because obviously you want somebody who the child knows and trusts. And sometimes they'll do them in their chambers as well. But not prevalent. And there's a lot of them. Actually, they were just going down to Canmore this weekend to meet with Laura Yasnik, who are indicated for training is really good for some of them, because most of them aren't comfortable. I'm not sure, does it happen here at all?
What?
Judicial interviews?
Yeah, it just recently, there was a decision, I think it was December, and there's judicial interviews that took place, and so that's, I think.
Yeah, I think I read, you sent me that case, yeah.
Okay, yeah.
Now, when the bench was old and male, it was, they didn't want to touch it.
Judge Dale did some.
Did
Yeah. Oh, yeah, Marie there and Portage, and I don't know how many he did, but.
I'm surprised because when I raised it, it was not gonna happen.
Well, maybe that was that particular case.
Yeah.
Judge Mike Paxton. And we've got guidelines drafted. They're very high level.
Yep.
But they're going to be distributed before the next family law meeting. And that's what I said. Yeah, I did one.
Yeah. And again, it's one tool. one tool in a toolbox to use. It's not every file that needs it. It's not every file that should require it, but certainly I think Children's Council can be part of helping you decide when to do it and to be there and there's even discussion about maybe Children's Council having a meeting with the justice and event to tell you a bit about the child, say what their interests are. So again, even in a judicial interview, you got to do the same thing as we did today. You have to build rapport with a child to get them to open up and be willing to talk to you. So just one way of doing it. So it's interesting to see how it is evolving a bit across the country. And if anybody wants a copy of that paper, God knows I sent it out enough things on Friday. She'll never want to see me again.
Yeah, I can send it over.
Yeah. Yeah, I did. Parents' evidence, a couple of concerns with that. It can be unreliable. It can be very biased. I'm sure you're all shocked with that. And it's often their interpretation of the child's views and thoughts after what the child may not actually reflect what the child thinks. But remember I said, kids will often, they have to cope, dealing with different people, different homes, different things. They'll often tell parents what they think parents want to hear. They'll say, Mom, I want to live with you. I don't want to go dad, same thing. It's a coping mechanism. And sometimes that's just the easiest way for them to get through things. Like you even heard our young Simon at that point. Simon talked about, and it was in the role play, that when he wouldn't go to his mom's, when he wouldn't go to his dad would yell and scream outside the house until, he didn't talk about that, but that was in the role play. The dad would yell and scream outside of the house in the front yard and just create such ruckus and yelling and screaming at the mother and threatening her that he would just go, just to stop the conflict. Just as he goes now, just because it saves things and it saves the key sort of thing. So Children's Council can use cross-examination as an indicator of a parent as a means to get out children's views and preferences. And I put things to them. Would you be surprised to hear that the child said this? Yes, no. Again, you always have to remember, your question and cross-examination is not evidence. It's only the answer that's evidence. But you can set things up.
My question is this, and it's coming back to what we talked about, appointing child lawyers. When you have young children, children under 10 years, where it's 8, 9 years old, 7 or whatever, and where there's evidence even through a parent that the child has some concerns that the child is experiencing discomfort with an arrangement or that it's really impacting on the child. So okay, you can get some affidavits from friends or from teachers who will likely not be willing to get involved. But how do other through a counselor, psychologist, how do you get anything from a young child where there's clear indications that things are not good, that the child is not happy with the arrangement, that it impacts on the child's mental health? How do you get that before court?
Well, sometimes we do it by way of the summary of court, so that's why we have that provision. And sometimes you need to hire an expert. You need to hire a parenting expert who's going to meet with the child and be able to give that evidence before the court. So you've got somebody to call.
Yeah, and the problem is up here we're limited in terms of the availability of experts. For instance, the psychologist here, if they hear the word court, then everybody shuts down. So good luck with that.
Yeah. Well,
in value setting, children are generally comparable witnesses in Ontario. The only difference being that the court is always cautious and barely orders it. There is always an application prior to that order. There's a threshold that has been set, so much precedent by the court when to make those orders, and it's quite a very high threshold. And I've had to witness in court the child protection proceeding where it was sometime, I believe, in 2019, where it was a case of discipline by a mom to a child where there are bed marks all over the child's body. The child's lawyer was ordered. There were so many controversies over time. The long and short of it, ordered the child to testify. When the child was brought into the room, the child has not seen the parents for quite some time. They could not hold the child back. The whole court would, as if the child wanted to go and hug the parents, He went crazy when he saw the parents.
Yep.
And the workers, no one could stop this child. She was screaming and shouting. It was about 9 years old. He just ordered him to leave. He went up to the parents and was crying. So I just told everyone that they should not talk because he can't conceive what he saw. They had to settle that case that same day, and the child went home with the parents. So it's a tricky thing to really decide and where to find the balance. But the truth is that that's actually one side of it when it was positive to the other end. It was a case where the school made an allegation that they wanted the child with a belt, and the parents were denying that. I don't know what was true, but that was the experience we had. That was inside the Ontario.
Yeah, and I know we will often do everything we can to keep a child off the stand. There is going to be a paper at the National Family Law Conference. You're going to hear me talking lots about how important it is to keep up your continuing legal education and get more training at the National Family Law Conference, which is a national one all across Canada. You have people coming and talking. There is going to be a paper at the July one on one of the lawyers from Nova Scotia Legal Aid is working on it. It's on children testifying in family law proceedings, and she's looking at what's happening across the country with children testifying. So that will be an interesting paper to see what all the findings are. But I know my practice is I do my best to keep them off the stand, unless you might have an older child who may wish to testify, and you still have to be really careful. I've unfortunately had the experience of a case where I was in children's counsel on a matter, but there were 3 kids, 2 kids aged out and were now adults. And there was 1 child that was still subject of the parenting dispute. And 1 older child was with mom, and 1 older child was with dad, and they each called them to testify against the other parent. So children's counsel can't cross-examine her own client. She knows what their thoughts were when they were children. She can't cross. So I put on a limited scope retainer for the sole purpose of cross-examining the 2 children. And the adult children, they were both in university at that point in time, but that was even an awful experience to put a child. They're not even children anymore, but they readily did it, and it was a terrible. How do you undo that damage down the road? Really hard to do it.
In terms of the academic, we very, very friends too. I had a personal experience where my client was very much aware that the children wanted to live with them. The child's lawyer was appointed, and instead of the child's lawyer asking the children, where do you want to live? Because the abuse have been very clear. They had an issue with the mom. The family was an Egyptian family. What the child's lawyer asked the children, I'm sure you would like to spend time with the mom and dad. And they both said yes, with the boy and the girl. And he came and made the representation in court that the children want to be 50-50 with mom and dad, which usually most people will say. I made a very serious mistake in that case because my client was very, very clear that children didn't want that. Eventually, we went ahead and got someone who prepared an affidavit evidence for these children and submitted it in court. George was very, very angry with us.
Oh, I can wholeheartedly see why.
Especially me as counsel.
Mm-hmm.
I told my client that I will not get involved, but he got someone who did, and she wants me seriously. Don't ever repeat this. Don't do it again. So, in terms of doing an affidavit, that has been my experience. And
doesn't work out well for the most part, and reflects poorly on the parent that puts a child through that. So you have to be very, very careful. So I eagerly await that paper to hear what's happening. But there are mechanisms if you do need to call a child, just like in criminal matters, sexual assault cases, sexual abuse cases, kids do have to testify. I had one file recently where I had 3 kids. I took it over from another lawyer. 3 kids have been through a complete trial on the sexual abuse allegations. They were pretty consistent on their position. The dad got acquitted. We were still dealing with the family law stuff, and he wanted them all to testify at the family law trial, which they've already been through once. They're like, so I came in, I'm like, how am I going to get their evidence for the court? Because I sure don't want to put them through that again. So I had come up with a mechanism we were going to use, but ended up, once I had shared their views and preferences with the court and with him, he went back and talked to a number of lawyers, and then he decided not to pursue the matter any further. because I think he was told if Children's Counsel was saying this is, and they've been through this, and they don't want to, then they wanted, no, they didn't want him to know where they lived, they didn't want any contact whatsoever. And he was going to push it to a trial to have them all testify again, but the justice was having none of that. So if you are thinking of doing it, you got to be really careful about what it is. You'd have to really prepare your client, but you have to be so careful because you don't want to put a child through that. Because again, when you testify, you're subject to cross-examination. So in Alberta, we have this mechanism, which is called an emergency protection order. I'm not sure if you have them here, but we at Legal Aid Alberta run a program called the Emergency Protection Order Program. So we help people in obtaining, victims of domestic violence, in obtaining emergency protection order. Every once in a while, we'll get a child, or usually an older child, usually 14 and above, who want to get an EPO against their parents or one of their parents. And the concern is always, if they are the applicant in the matter, then they're going to be, if it goes to a trial, they're going to be subject to cross-examination, and do you want that to happen? So we've worked at that. We can sometimes get Children's Counsel to be involved. But Children's Services, it's part of their mandate to assist children if there's family violence, and it's their mandate to bring emergency protection orders on their behalf. They don't do it in Alberta. It's just one thing that they won't touch with a 10-foot pole. But those are the situations. Would you want that child to be the subject of cross-examination on an oral hearing on the abuse issue? So we'll do what we can to kind of keep it up. So back to other ways, direct evidence from the child. We've talked about a lot of this. Capacity, do they have the capacity to even swear an affidavit if they were going to do it? Again, I've never done one ever in my days. It's extremely rare in family cases, more frequently used when they're criminal, when there's necessary to get that evidence, particularly in sexual assault cases. Courts are extremely hesitant, and that's my experience, that they're extremely hesitant to place a child in a situation where they'll be questioned or cross-examined by parents are made to observe their parents' dispute. I'll do everything in my power to keep them off the stand. I'll be as creative as I can be. Children may be included in alternative dispute resolution options, like if parents are going to mediation. Sometimes if you have Children's Counsel, if you're in court and you come out of court to do it in mediation, then sometimes Children's Counsel will be involved, or in sometimes in an arbitration. At Legal Aid, we don't appoint counsel unless it's in the court process, so we don't get involved in that pre-court process. If a child does need to testify, you've got to do absolutely everything you can to minimize the trauma to them, make use of screens in criminal matters, talk to your colleagues who practice criminal law as to what the Crown will do to try. From Directors' Counsel, do you often have children testify? Absolutely never.
I can do it on that, but I don't think, certainly not. I've never.
Yeah. So, and as I indicated, there is no special lawyer who's working on a paper, so it'll be interesting to see and she's canvassing across all of the legal aid plans and all through ALAP, I think all the legal aid plans, what's happening in each of the jurisdictions. Video, as I talked about, letter, I'm always extremely concerned when I see that. If there have been cases where we may want to sit down with a child, if they really want to put something to the court in writing, that we'll work with them to prepare, not tell them what to put in it, but it's under those circumstances, you can get a little bit more confidence that it is truly the child writing it. There's not pressures behind the scenes to do it. When you do see the ones where the parent has Jimmy write a little letter, what was happening, what was the situation, what's happening there. There's one decision out of Alberta, it's a while ago. Justice Watson accepted a letter written by a 12-year-old girl who gave it much weight in making his decision. However, both parents testified that they believed it was in the child's own words. That they, as I said, parents know how the kids talk. When you put back to them what the language of the child is, they'll recognize that. And both the parents agreed that the child hadn't been coerced in writing the letter, and it actually sounded like what their thoughts were. Other adults, we talked about this, having a teacher, a doctor, access supervisor, child welfare worker will often testify. It's hearsay, but sometimes it can pass that necessity test. It would be considered more reliable than a third party, like a parent or a grandparent sort of thing. And you can also have a practice note in Alberta where you have a voice of the child report. Again, I think I've talked lots about the voice of the child report, so they can be evaluative or non-evaluative. Evaluative ones are done by professionals, psychologists, usually social workers with masters. They evaluate, they look for that sense. Is there signs? Is there red? We can point out red flags of alienation. We can't make diagnosis with respect to it, nor should we. It's not an assessment, so a voice of the child report can't make recommendations. This is what the access arrangements should be. This is, they should live here, they should go there. Can't do that. They can make recommendations. Maybe the child needs counseling, or maybe we should look at this issue or that issue. But only a parent in the full parenting assessment can make recommendations. There's very strict rules with the College of Psychologists in Alberta as to what they can recommend and cannot recommend. Some lawyers will do what they call a voice of the child report. Some people do like a verbatim. It's a non-evaluative one. BC often uses it where they literally meet with the child, they write down everything the child says, and it's a point in time. They send it to the justice, they send it to the parents, but it's a point in time. One of the nice things about children's counsel is you have an evolving relationship with the child. You're not just there for one thing. Kids can change as their ages and stages change. They can change their views and preferences over time. We talked about the consent. If you have consent from both parties, then Strobridge will allow you to actually not be a witness, but give evidence from counsel's table for that. If you've got consent. If people are not consenting, then you cannot do that. It was the RNFP decision out of Alberta back in 2016 where we got that provision in our order, which allows us to provide the summary of court. Court found it very helpful. Most justices, from my experience, is they're just so glad to get any information about the child, that they're not as concerned. If you're at a trial, different story. But during most of the litigation, when you're doing docket appearances or you're doing case management meetings, they're happy to get any and all information. I don't know what's kind of the perspective here. Are the courts generally happy to get some information from children's counsel?
I believe so.
Yeah, yeah, it's helpful.
Definitely, just what you said, the more information we can get, better, and we have to evaluate it, of course. But
Yeah, as to how much
no
weight you're giving
information
it.
is the worst.
Yeah, and that will be great when we talk about tips and tricks. Like, what is it you want from children's counsel? You want to get information. It's up to the court to decide what to do with it. But if you can help them collect that information, voice of the child report also allows the lawyer to call a writer to take the stand, and that's a big issue we have. Like, I often won't get a voice of the child report unless I'm going to trial, when we do need to have somebody give that evidence. Judicial interviews, we talked a bit about, not super common in Alberta, but becoming a little bit of momentum happening. Different forms are used. Some judges, there was one case in Alberta where the judge actually went to the kid's school and met with the child who did an interview there. We've had other ones in Quebec where it's quite prevalent that they actually meet with children and making decisions on parenting matters. It can be in a courtroom, can be in judge's chambers, recorded or not. That's ultimately totally up to the court to make those decisions. Counsel can make the positions going on it, but it's up to the court to decide who should be present, what stage should happen. I find it's almost the last resort in many cases, and maybe if it were heard a lot earlier, we wouldn't have 10 years of litigation. The ones where we see it tend to be those really long-standing, high conflict matters. It may have helped a lot earlier in hearing from kids. To the extent that children are harmed by being caught in between warring parents, there's no research to support the view that meeting with a judge exasperates us. And that's some research from Nick Balla and Rachel Birnbaum out of Ontario. Hearing the voice of the child in the family justice process, the role of judicial interviews was one of his papers that they wrote. Again, I said last resort. It's often seen as the last possible thing to do, but maybe it should be considered much earlier. And again, it's up to the court to decide if they want to do it. It's up to their comfort. Some justices, I had counsel who were members of the Office of the Children's Lawyer before they became judges in Ontario, and they were great with kids. And they're telling me I wouldn't do it. I'm like, what do you mean? You work with kids for years. You have the skills, you can do it. No, I won't touch it. So, and again, Justice Leparco has some guidance on her paper from the SK decision. That is well worth, even though it's an Ontario case, it's well worth a good read. It's a really good decision. And she had the paper that Jeff and I assisted her with. Parenting assessments, again, I'm not sure how often they're actually ordered here, but they are so expensive. We're talking 20 to 40,000. It's usually for the very few rich people who can afford them, because most of us cannot. They usually take a really long time, and they're dated by the time you get to trial, and usually you need updates. But the good thing about them, they can make recommendations. They're going to meet with the child. They're going to meet with the parents. They're going to meet with any and all collaterals that are involved in this. They're gonna get to the heart of it. They're gonna talk to child services. You should get a really comprehensive one for $40,000. That's it. Those are the ways. Are there other ways that you're getting evidence before the court? Or is getting the children's evidence before the court an issue that you're at all concerned about? Sounds like less things go to trial here, which is great. As children's counsel, how are you for the most part getting your information in?
Well, we're writing a letter and
Okay.
for that, my practice was always to send it to council. Because my hope was that when everybody got a
Heard,
chance to
yeah.
sit down and read it, we resolved things and it never would go to court, and that did please them. But we're also now filing it with the court so that the judge has the letter, at the time of the hearing.
And are you putting any sort of trust conditions? Are parents allowed to have a copy? Have you had
Well,
experiences
parents-
with them meeting with
Yeah,
kids after? Yeah.
And when I say it's not a report, it's a letter.
Yeah.
And the parent, if they're representing themselves, then yeah, they're each entitled to a copy, and I don't think I've ever put trust conditions on, but that may be something that I.
Yeah, I can give you some precedents for
Yeah,
that.
yeah.
Just, and sometimes I've heard of other counsel will ask that the letters be sealed on the file. So that if somebody does a search at a later point in time, they can't access that information. With our PN7s and PN8s, we have tons of rules about how you can view them and that sort of thing for yourself. Which in some ways, when I first came from Ontario, I'm like, what do you mean parents aren't allowed a copy? It's an assessment of them, and why aren't they allowed a copy? But again, it's like, I've had also files where kids have shown me, oh, did I say this? Did I say that? Mom told me about this, and they go through it line by line with the kids, and that's the worst thing. But sort of I'm less concerned about them seeing it and more concerned about where it goes after. Putting in, like, people are so quick to put things on the internet, and once it's out there, and for kids, like, they don't want to see that. It may never go away, sort of thing. So, questions, thoughts? Go ahead.
So, I guess my question would go to situations where we have a voice of the child report that has been produced. That is quite opposite to the counselor's report that has also been produced. Because there are usually such scenarios that do play out in how you would
Counselor's report, when you're talking counselors, are you talking like a therapist report?
Therapist, the counselor,
Okay.
seeing the child,
Okay.
with consent of both parents. We do have some situations where the other parent wants to present his own evidence, perhaps the dad, the mom has the child, the views of the children has been expressed through counsel, and then you see a scenario where the counselor that provides her counseling notes and a letter of what the child has been saying consistently for quite some time, and they just diametrically opposite. Such situation, how would you handle it? And one thing about Yukon is that in Yukon we do have a kind of merged roles where council, once appointed, can do a whole lot of things depending on their own discretion. Well, as I know very well in Ontario, we have 3 streams provided by 3 different legislations that it's possible that a voice of the child report can be ordered by the court. In that situation, counsel is appointed and the counsel is a compellable witness. It's not an advocate for the child. That's under section 112. Then we do have that a scenario where a clinical assessor is appointed by the same office of the children's lawyer.
Like, we're in Ontario now, right?
Yes, in Ontario. And that's
Extraordinary jurisdiction.
yeah. And that's under section 30 of the insurance law
So
reform.
you're saying the children's counsel can be compelled?
If the appointment is solely for the voice of the child report, because when we attend court and appointment,
Not with the social worker says.
no, with the social work, that's a different thing. That so we have appointment of an advocate, a lawyer for the child who appears, makes submissions, and carries out her duty as counsel to the child. We do have counsels also do not appointed to only do a voice of the child report and just report exactly what. Yes. And then we do have a clinical assessor who can be appointed under Section 30 of the Children's Law Reform Act. And in such situations where we attend court, there are always submissions to court, every counsel trying to sway the court on the exact appointment they want. When there are allegations, especially by both parents as to alienation, the court will be looking more favorably towards appointing a clinical assessor who are up to social workers. And the difference is that they go beyond what the child has said and they look at the underlying issue.
Yeah, they're giving the value.
They contact the police. Usually there is a consent form sent out. The Ottawa police is always very open to cooperate and provide their own report. They contact FCS, they obtain all the records, and they usually are very detailed. Not just they go beyond recommendation, but to provide reasons for those recommendations. The only thing they don't reach is any conclusion, but they also do assessments. And that's very different from what the child's lawyer will do when doing a voice of the child report, which is simply to report verbatim what the child has said and in what circumstance. Sometimes you see things like there is only 2 rooms in my dad's house. It's not convenient. In my mom's house, I have my own room, and I like to spend my time alone in my room. That's the reason why. So these are quite really different reports, and we calibrate and strategize very carefully to ensure that the right report is being easily ordered by the court. But we have situations in Yukon where it seems just a general appointment is being made, and the duties are of counsel to choose how and what format that report will be provided. So I guess my question is, in situations where there is a clinical report that opposes whatever a lawyer has done here, how would one be able to entertain that in terms of those 2 contradicting evidence in court?
Well, I did think if that's the case, if you got a children's lawyer saying, look at it, and you've got something that's more value to it, if I'm done by parenting, but I think you're going to want to actually push it to the parent, because there's going to be classes on that. And then you're going to get your parenting expert giving the base. Children's counsel will give, remember, children's counsel are doing the views and preferences of the child. They're not necessarily, we talked about best interest, it's not, you're making the best interest, not what you want, you're sharing what the child wants, not those instructions are what maybe under that. But that's the child's perspective and that's the child's view. If you have a parenting expert who's going to evaluate one, they're going to look at the underlying, not just what the child wants, but what's behind it, making it into what are the allegations of allegations and things like that. So you're going to get a much more evaluative approach. So I would suggest in those cases, you actually push to them. So you get the assessor, but not the assessor. And now with children's counsel will still have an opportunity to cross family as well. But I don't think you're gonna have, I don't think there's probably many situations where children's counsel is getting enough on the street for that. Yeah, no, I don't know what you want that. So you have to be strategic as you go to have somebody parents counsel and that's the person. How do you want that evidence? Do you want the opportunity to cross family? That's it. You go to retain your position, but it's
Okay, so now let's take the situation where you child lawyer like us here, so you give the child's preferences to the court, and it's, I mean, okay, you've already determined the child is of an age and has the ability to give instructions, but the child still has limited insight in the real world. So, which brings me to the question of when you make your submissions to the court, what about child's best interest? Because your argument about what's in the child's best interest may not line up with child's wishes.
I mean, use your role play, got the 12-year-old boy. And
yeah, he wants to go there where there's no rules.
he wants no rules. You're the child lawyer. Pretty clear to you what's up, but also this child's wishes are also very clear. You know, is the fact that he can play as many video games as he wants, unlimited amount, and
you can share them, but these are this is what part of the reason why.
When, if you're conveying that to what the child wants to the court and at the same time respecting your lawyer-client relationship with this child, do you not have an obligation not to undermine the child's wishes with your own personal
Well,
feelings
then I
about-
think you're not necessarily undermining, you're sharing, you know, what's the reason why.
Yeah,
So when you're making that determination
Okay.
on capacity, does this child have the capacity to understand the consequences of their actions? And regardless, again, it doesn't matter what role I'm taking, I'm always gonna tell the court what the child's views and preferences are. But I may be telling you what this child really wants to live with dad. He has lots of freedom there. He's got the ability to play video games. He's got a lot in common with that. You may be sharing it. You have to have, remember, the ultimate decision maker is the court. The court is the one that makes the decision what's in the child. The views and preferences of the child are one of many, many factors that the court is taking into consideration. So they're not the decision maker. Make sure you make that really aware to your kids that you are here to share their views and preferences, share their input with the court, but they're not the decision maker. You're not the decision maker. The court is the decision maker. We're just gathering information to help the court with that. So I think you can do it without totally undermining them. That's what the interest and entitlement role. That's why I have a bit of a problem with that. Because again, I said earlier, I like being an advocate on some of my files because there are times where you do want the court to know the information as to why this child's preferences, the way to get behind it as to whether some of those.
I've seen a case where, you know, a kid no longer saw one parent because one parent had rules about the phone. So teenager then goes to the other parent and house and wants to stay there because they can have their
That
phone
happens
whenever
all
they
the
want,
time.
all night.
Yeah.
And now this child has no relationship with the other parent, right? But you can bet that what this child was just telling the child lawyer is, I want to live with my dad.
And as you said, you said the lawyer asked the child whether they know it, like, you shouldn't be doing that. So you saw how when I was talking about what works, what doesn't work, what you can and you can sort, you might like to change. I didn't say where you want to live, like you should never, in my respectful opinion, you should what's working, what's not working, can you change to it, what might go speed up? Do you want, you don't go, oh, hi, Joey, where do you want to live? You know, you get the information out of the time. But that's what I do. I'm not saying that's the only way, that's it.
That point, one way I tend to do to approach it, when we're never looking at each other, we're usually drawing, playing, and then we're talking now, say, so how are we feeling when we're at dad's? How are we feeling when we're at mom's? And just trying to open up the conversation like that instead of asking things specific about. I wanted to ask you, given your expertise, so we have this issue. Your experience, your cross-jurisdictional knowledge. So the focus of our conversation today is in this family law setting. And we're very fortunate to have the appointment of child lawyers, to the public guardian trustee, and that is generally age 10 and up accepted, that recommendation. Under 10, if there's an explanation as to why the child should have the appointment of a child lawyer, that's as long as we provide that explanation. In my experience, has never been rejected, which is great. And the courts don't always recommend it, and that's done after a thorough assessment. But then we still have this gap between the United Nations Convention on the Rights of the Child and something that Annette and I talk about a lot, which is that all children have a right to have their views and preferences heard when decisions are made affecting them. So we have this gap between what the UNCRC is happening and then the ability to get a child lawyer appointed around age 10. And I know through the Child Youth Advocate Office, they're interviewing young children often and are able to have that skill set and are ensuring that the voice of the children is heard in those decisions that are made by them, and they're very significant decisions that are being made. So just thinking today in terms of all the tools for us who do receive appointments to child lawyer, it is a bit intimidating to go into the much younger child set. in other jurisdictions, is that where they would potentially do a voice of the child report by a psychologist to help with that gap between UNCRC and what we're doing here in family law? I'm really curious about whether we could bring that to us.
Yeah, I can't say it's often the answer, but we do a person child report. I've represented kids as on the high conflict stuff versus the versus the child welfare stuff as early as like 4, 5, 6 sort of thing. Under that, I don't think we can get. Often it's because there's a sibling group with a number of kids and they may have different. But and then I just share, and often you don't get music from the child, and that's okay too. You can share. That speaks volumes to a judge who is got a young child. But you'd be interested, the younger the child sometimes, the less filtered the information is. So sometimes you get incredibly valuable information from those. What's working, what's not working. And you do it, then it's a lot more play. And it's like, and they can tell you who gets along, they can tell you what's happening here and there. So there is value to younger children, but it's got to be the right service. It's not every child. And when I indicated earlier that the Alberta law reform, that's what it's called, they're looking at the whole issue of voice of the child, and there's many people in the province. Trish Bear is one of those who thinks every child should have the right to have talk to somebody. It doesn't necessarily have to be a lawyer, but we should be looking at what's the voice of the child when we're doing research. Parenting leadership for child create. And again, it all comes down many times to funding. Who's going to be able to fund this? I know in Alberta we only do the high conflict, and we truly rely upon the court to assess the situation. Is this a high conflict on our resources should go into? So the kids that are, but many parents resolve their matters without going to court. And Trish does a lot of the work that I don't do. I deal with people who are in conflict and in court all the time. Her fact was she's doing mediation, and she's dealing with parents all the time who are resolving matters in arbitrations and in mediations early on. So it's less likely I would get a voice of the child report for the ones that I'm more likely to get for the ones where I'm really concerned about. That's and those are the ones that are much more likely to be going to that. But I have no problem in meeting with a young child and meeting with them, assessing, getting whatever information you get, and that's where you may be more likely to turn to an interest in entitlement role. Child's not able to get capacity to do instructions, but these are their interests as to what's important to them and share that information. And even that, I would assume getting some information is better than no information. So I think it is a gap, and there's always going to be a gap. And every government has to look at the resources and where they can put their resources, but in Alberta, and even in the Office of the Children's Lawyer, there's some cases they'll do representation of children in the child welfare side for their benefit. As I said, I don't always see the value of it for really young, particularly babies. You know, sometimes kids get apprehended in the hospital. I was like, what are they going to do? Go hold the baby and then their information is coming from the social worker, the information is coming from the hospital and it's not from the child. 5 and above, they can give you some really good information. But that one case I had where it was an end of life decision as to whether or not a child parents didn't want the child taken off life support, director wanted the child taken off life support, children's council had control of that. We went on the so.
So in Alberta, the child lawyer are representatives of children.
Yeah, on the child welfare side of things,
yeah.
High conflict stuff, not often, but sometimes when you have, like one of my lawyers for the boys in my office got them for 4-year-old twins. And a high conflict parent. So what are we going to do with that? Now the justice who appointed was a justice who did all kinds of ways. So she recommended things all the time in the child welfare system. So she expects everybody to be able to. That one may be a bit hard, but you can talk about what are the interests of the child, what's going on. You know, sometimes you're not talking to school, you're talking to daycare. Daycare see kids as much as anybody. That's just collecting some of the information. And often there's something attached to it. There's medical issues, or there's religious issues, or cultural issues. There's usually something else. It's not just there's 4-year-olds around it. So there's usually a specific reason. And I think the courts are really quite attuned to if they are wanting children's counsel appointment for younger children. And maybe that's something that we explored in Yukon if you do want it for children when you're asking the office of the public guardian and trustee to make that appointment, give some good reasons as to why and what value you're looking for. And we can say that to some of the we have a referral form that we're now getting the King's bench to use when they're making. It used to be with Alberta, parents had an order to be made, and parents had contacted Legal Aid Alberta to get counsel appointed. And of course, sometimes they don't want counsel appointed, so they're never going to contact us. So we've now got a program where the justices send over the order to us, and we can appoint from there. Sort of thing. So, but sometimes having a little bit of background from the court is good. Sometimes there is a specific issue that they want children's counsel to focus on. It's an education issue, or it's a medical issue, or
It
it's
might be something that the parents are intentionally not gonna provide them the information on.
Exactly.
It's not
Hmm.
gonna help what
Yeah.
they.
And that's sometimes when you get that amicus role, you're there to ensure that. And I still personally just sparkle, and I will never agree upon it, but well, we're getting close there. I got a provision where we can do it, but we need permission. But there are some times where you do need somebody giving you information, the good, the bad, the otherwise, so that the court gets all of the information in the decision. Because remember, you're not the decision maker. People think, other counsel think you're the decision maker. You're not. You're just one of the parties, and you're helping the court make the decision. And that's why they very much wanted away from best interest rule. Sorry, I'm not ready.
That's good. No, I had a question about your letter. If you do a letter or you're not doing that sit down meeting, but you're presenting something in writing, do you ever give your clients or client a chance to read the draft and provide feedback?
Sometimes I'll read it over the phone with them. Sometimes I'm really good. I mean, I have been as good at it today, but really going back, what can I share? What can't I share? And there are things that don't want me to share. We'll talk about that. Like, you know what, I might not be able to get this point across unless they share something. Is there some way we might be able to do that? Or is there some way I can put it this way that you're okay with? And if there's ones that I'm really not sure on, or I really want to ensure they've got their approval on, then I'll call them and we'll read it out sometimes, or we'll review it. I really try never to share anything that they don't want me to share. But if they don't want me to share things, and I tell the court, there's a lot of things they don't want me to share, that usually speaks volumes. Speaks volumes to your lack of sharing. And when it comes to the alienation cases, there are some materials over there on, again, I should know the case off the top, but there's one case out of Alberta. The case itself is not great for alienation, but it's a stick back, you take the back, but just red flags to look at. That's a good one. You're not sure, just go through that. What did they call? What were the names? Like, just kind of, and I've done that in a trial, like, the justice very safe, and saw evidence, and as children's counsel, you're doing submissions at the end. We heard evidence of this, we heard evidence of that. You're not saying the alienation, you're just pointing out. Maybe somebody when you see how they talk with, and you don't have to give this out. And there's also, you know, there's different levels. There can be reasons why kids aren't wanting to spend time with parents. Sometimes it's a natural issue. There's abuse happening. They don't want to be with. That's okay. Sometimes it's just affiliation. You're more affiliated, like we saw Hunter. I'm trying to remember what name I do. Hunter. Dad is his coach. Dad's really into hockey. Dad's really into video games. They've got a lot in common. We may want to spend more time with them because they're more alike. Sometimes teenage girls want to spend more time with their parents. As kids grow older, they want to spend less time with their parents. They want to spend more time with their parents. And that's natural. That's not necessarily as an alienation situation. That's just, they want to spend a lot of time with parents as they grow older. And then you get some of those cases where it really is behind the scenes things happen. And most of the high conflict cases that I've dealt with, there is some influence. Vast majority of cases, it's natural. It doesn't get to the point where it's super concerning. Those are the cases where we in Alberta can bring back to the court and say, in extraordinary cases, I'm really concerned. Any questions?
So how often do you speak with third parties where there are a lot of allegations connecting them, and how much weight do you give to that?
Sorry, when I talk to you about the
Third parties, like
third parties, grandparents.
that could also
That's
include like possibly the school.
Yeah. When I'm doing my work, I must admit, I don't talk a lot to family members. Like I told you, I don't talk to Brown. I generally talk to professionals. I put a great deal of weight on what a principal has to say and what they're seeing of the child in school, or if there's actually different issues. Because remember, they're independent, they're not on mom's side, they're on dad's side. They're there quite often in school, there's a big deal about this child in this weekend. So what they tell me, they're really probably very loud.
Do you ever find that they're not neutral?
Sometimes I sometimes find it in cases where you have step parents involved and step mothers and sometimes step moms or something. Where, again, that's sounding awful, but sometimes they'll try to end the situation like that little girl. I talked to her the first time she came in on Lisa was the stepmom, mother, and she had, sorry, did I say that? She was the stepmother. She had spent so much time sort of putting things into this child, and she had told the school everything. So I went to talk to school, and no, that's not what the order says. That's not this. That's not that sort of thing. So, and you can tell those three. And the whoever is the first receptionist or the school, they know more than anyone.
Yeah, the breadcrumbs are there. There's
Yeah.
a trail.
The principal might hear some stuff, and I'll often ask kids, you spend much, do you know the principal? If they don't know the principal's name, that's a good sign. A lot of time with the principal. They know their teacher's name, that's good. If they don't know the principal's name, that's usually a really good sign. They're not in detention, they're not there on a regular basis. But I find overall, if you develop relationships with the school boards, like I have relationships with council for the Edmonton School Board, the Edmonton Catholic School Board, the Red Deer School Board, I help with them with their policy, because they're like, who are these lawyers sending me shit? What do I have to give them? You work with them, explain what your role is, you're there to help the child, they're much more relevant. Parents have to contact anyone for them. Children's council, they're usually really well, but have an order in place that gives you that ability to do so.
I was curious, we were talking about sometimes visiting the children at school.
Incredibly.
Yeah, and like, what do you do, like, in my mind, like, I would imagine them sort of disruptive for the child if they didn't know ahead of time that you were coming, but,
Oh, usually most of them are teenagers. I don't do it without their permission. They
Yes.
want to call their other kids love to go back. I just
because I just think I just got to walk in class.
And I usually talk to them, is it okay? Is it okay? And I won't necessarily do it unless I think I've got concerns that I
About
really
who's
like.
dropping them off in the car ride on the way.
I'd like an independent where nobody knows I'm coming. Do I have to ask permission? Apparently no. My order allows me to put them wherever I want.
You have relationships with schools, and
Yeah.
things that they know.
And schools see kids more so than parents. Honestly, being a practicing lawyer, I'm sure the schools saw my kids more than I did in certain periods of time. And kids are open, and they know when kids are, like, sometimes they'll tell teachers things, sometimes they won't if they're not. But they're often the ones who are making referrals to school liaisons or school
Or
counselors
they see
or
a
things
shift
like that.
and something that's, yeah.
And
Something that
sometimes
happens
there's
one week
absenteeism
and not
issues that are Mondays or Fridays, or there's dreads, like, I've even had files where schools had to get restraining orders against parents for showing up. And so that's it. Oh, sorry.
That's fine. You made a point earlier that it went by too quickly for me to really take it in. It was around the role of guardian ad litem, which I understand to be
Messages.
a civilian, maybe it's a parent, maybe it's somebody else who is taking on sort of the legal guardianship of their child and asserting their rights indirectly or something like that. And I took you to say that that was sort of falling out of favor as a way of getting
So
children's.
that was a role where the lawyer became the guardian of the child. And the lawyer put in their views and preference, their not views and preference, their position. They became the best interest in that. So regardless of what the child wanted, the lawyer, as guardian ad litem, doing the best interest role, would then say, this is what can happen for this child, regardless of whether that's what the child wanted. So the courts, particularly in Ontario, have been very, we don't want that. We don't want the lawyers telling us, we're here to determine what is in this child's best. You can still make arguments, like there's many factors. Your best case analysis and you can still make arguments about, but you're not to tell us what is the best interest of this child. It's us. You can tell us what their views and preferences are, but they don't want you doing the best interest. They don't want your subjective views. They want what the child is sharing, or you move on to now.
in, in a situation where, it's also related to a third party opinion. But in a different scenario where there was an ongoing child protection proceeding in court, where no child lawyer was appointed, and the position of the Children Aid Society as the equivalent of FCS was that the mother should not have supervised parenting. She only have supervised parenting time. Just at the trial management conference, the judge decided that FCS position was unreasonable. He was very outspoken about it. There were a whole lot of negotiations that went on in court that day. The judge was like, supervision is not a permanent position of the court. She's been having parenting time for an extended period of time without issues, but it was in a supervised FCS setting. So he told FCS that he doesn't think that the position it's right in this case. So he decided to negotiate, and he withdrew it after that day. But there was an ongoing domestic proceeding. There is also a family court case that was ongoing, was suspended when FCS became involved. Now, in that case, the children's lawyer was subsequently appointed. And during the course of the proceeding, there has been different applications. The court has increasingly increased her access. She says she had no issues with drinking anymore because part of the issue FCS had was that during the course of the family law court proceeding, she had 2 DUIs. One of them with the children in the car. So that's why they triggered the child protection proceeding that was withdrawn subsequently. Now, during the process that the child lawyer was involved, the child's view was very, very clear that she wanted to have much more time with the mom. But the mom lied to the child's lawyer ultimately. Say she's quit drinking, gave a whole lot of lengthy stories for them. She pulled police report and found that she had 3 further subsequent issues that the police were called. One was from work. She was arrested, taken to the hospital, shackled to the bed. And that was just during the course of the investigation. So contrary to the child's view, her recommendation that she should only have supervised access, and another judge found that she should be so. In that kind of circumstance, do you think that our opinion should override the views and preferences of the child?
That's similar to like in her situation that you indicated. I think in that, if that were me in that particular situation, I think what I would probably do if I'm so concerned, I'd probably go back to the court and request the opportunity to move from a direct applicant to a campus so that I could then put all the evidence before it. Still put the views and preferences of the child. The child wants to have lots of contact with them, and wants to have contact with them. But these are the other things that happen. So the court has to have the evidence. Because remember, you're not going to child services there to put that evidence in. Otherwise, how is the justice system? So then you may not be following or you may withdraw and recommend that the next council be an amicus. But it's a fine line as to does he have capacity? Is it only because when certain like police do different things or the other side? But yeah, difficult decisions. Sometimes a lawyer may even have to contact a practice advisor.
I know that in some cases, lawyers use coded language with judges, such as there's been a breakout in sister-client relationship, and that conveys meaning to. Is there, I mean, you're talking about situations where the lawyer has serious concerns about the welfare of the child or whatever, but they are that child's lawyer. I mean, is there coded language that's been developed in this domain that people use?
When you say really carefully to a judge, my instructions are. Like you say, gentlemen, my instructions. These instructions of my child is really consistent, but if you're doing a direct advocacy, And technically, you can't bring in that evidence. That's against your client's position. So you have to really hear it. But I think you have to rely upon justices to, they're gonna get they're gonna get the information they have, and sometimes you can tweak them by what my instructions are. And I think so it looks like 3 o'clock. By all means.
I wonder if you have any experience in bringing children in and thinking older children in the Indian culture and the dispute resolution process, and how and what role they would have and how that would unfold. Did you mention in your one of the
Yeah.
provisions?
Are we talking alternative dispute resolution?
With the judge,
Or
like
with
an
the
judicial
judge?
settlement
Like a
conference?
JDS.
Yeah.
Yeah, lots of experience with that. What we will do often is, particularly if you have older children on child welfare as well as on the high conflict stuff, just allow the child to come and sometimes say their piece, either through their children's counsel, and if the child wants to be present, they'll have them come and share their views and preferences. And then we need to allow the parents to then continue with their discussion. So give them the opportunity to share what their thoughts are and what works for them and what doesn't work, and then have them leave so the parents can continue to negotiate.
So would the parents be able to ask questions, or would that be just the judge would?
The judge
manage
asks
that?
questions generally, hopefully, if you had that children's counsel involved, and hopefully children's counsel's already done their work. They've had that meeting to
So-
allow parents.
So it would be more for the benefit of the child?
Yeah, more for the benefit of the child, for the parents to hear direct. Because at a disclosure meeting that I had talked about, we wouldn't necessarily have the child there. And sometimes I have had cases where I've done one of those meetings, but I've had the child there just to share their views and preferences, and then they're not part of it, they're already. Then the negotiation. Now that you've heard from the judge, and one of the things that I said this morning was, I did a role play, and I always say to kids, I'm gonna take notes. Because I'm old and I can't remember stuff, sort of thing, and I ask permission. But I try when I'm doing it to write down in quotation marks where I can the exact words of a child. Because that can be incredibly powerful for parents to hear, because they know how the kids talk. Does that sound like, you saw the case I put up there where the child had done a letter, but the parents knew by reading it, that, oh, that's exactly how my child talks, and that's exactly. Hearing, many of the cases, just hearing from what the child wants can help as well. There's always going to be that 10% of the high conflict cases that take up most of the court time, and those are the antisocial behaviors that are, doesn't matter what's going on, they're going to take up the time. But most parents, once they hear from what kids have to say, a lot of the class will resolve it. Or you'll have some input on. They may not get exactly what they want, but they have some input on. And you know what works for them, what doesn't work. Why wouldn't we want to craft something that works for them? What their schedule is. Like maybe they don't want to do a Wednesday sleepover because they're doing this or they're doing that sort of thing. And kids are much more likely to, particularly teenagers, go with and live with a schedule that's imposed upon them if they have input on. They don't have input, they're gonna go with the beat. They're gonna do whatever the heck they want to do. And there's not too many police officers that are not driving them back, and screaming. So and even with child services matters, it's like if you don't listen to them, they're gonna run. And wouldn't you rather them with a parent who cares about them than living on the streets? Because that's often what you will see. I've had files where I had one where I was brought in at the trial stage, literally I met this kid weeks before the trial. But the justice is going to hear about her, and this kid wanted so desperately to live with her mom, was living with her dad. And if she went to her mom's, the dad would have her mom arrested because that was what the order was. So she ran away and was living on the streets. And the judge is like, what are we doing here? Because they're so entrenched, and the level of conflict in front of, even on the cross-examination piece, the justice and I just looked at each other and we're like, oh my God, it was running through my mind. If this is how they behave in a courtroom in front of children's counsel and the justice, you can only imagine what this child has experienced. And the next day the judge read, and it was the exact thing that was running through my mind, sort of thing. But again, is it better to have them with a parent? And this wasn't a terrible parent. This was just they had so much hatred of each other. He just would never, anytime she went to the call police, and she just desperately wanted to be there. So the court wanted to have count and literally appointed a week before the trial. He did a lot of work in a short period of time, but it was helpful. It's helpful for the court. Anybody else have questions? Otherwise, we will take a break, and I think at 3:15 we'll come back with our panel.